Hey everybody, Knox Williams with the American Suppressor Association, and today we have an extremely exciting update for you on Anderson v. Raoul, the ASA Foundation and Silencer Shop backed lawsuit against the state of Illinois, challenging the constitutionality of their suppressor ban. The update, provided by ASA General Counsel Michael Williams and Silencer Shop General Counsel Chris Boeck, will tell you everything you need to know about where the lawsuit currently stands as of August 2023. Let's jump in.
Hey everybody, I'm Michael Williams, General Counsel of the American Suppressor Association and the American Suppressor Association Foundation. Today we're going to be discussing updates in the Anderson v. Raoul case, which is the case that you'll remember that ASA-F and Silencer Shop are involved in that challenges the constitutionality of the Illinois suppressor ban. I'm very excited today to have an opportunity to chat with Chris Boeck, who's General Counsel and Head of Compliance at Silencer Shop, and he's also an ASA-F board member. As you probably know, Silencer Shop is the country's largest distributor of NFA-regulated firearms. Prior to joining Silencer Shop, Chris was a partner at Locke Lord, a full-service Am Law 100 law firm. While with the firm, Chris provided commercial and regulatory guidance to clients in the firearms industry, including federally licensed retailers, distributors, and manufacturers. Chris is a member of the State Bar of Texas and is admitted to practice before all federal and state courts in Texas, as well as the Supreme Court of the United States. So Chris is a true litigator and has presented oral arguments before each of the federal district courts in Texas, as well as the Fifth Circuit Court of Appeals. And he also had the honor of sitting at the counsel's table in oral arguments before the Supreme Court when Justice Antonin Scalia sat on the bench. I want to take this opportunity to thank Chris and also to thank Silencer Shop, who's the major sponsor of this case in partnership with ASA-F. And it's really just a true statement that this case would never have gotten off the ground without Silencer Shop support. So thank you for that. Thank you for joining us. And Chris, if you wouldn't mind, could you give us a little bit of background as to why Silencer Shop chose to support this case out of all the things in the Second Amendment community that Silencer Shop could and does sponsor?
Sure. And Michael, thank you for having me, and thank you very much for that overly generous introduction. I really appreciate the opportunity to talk with you about this. I know when Silencer Shop initially started talking with ASA about financing this litigation, it was something of a simple proposition, which is we want to ensure that all Americans have access to silencers the same way that they have access to firearms. There's no reason that somebody in one state should be banned from having a silencer, whereas their neighbors in another state have access under federal law to possess silencers legally. So we talked with ASA about challenging these states, and we looked at Illinois, we're looking at California. My thought is that, and we started these conversations about a year ago. In that time, the impetus for bringing this case and the issues surrounding this case have become much more critical. And we've seen case by case of district court level cases with judges finding that silencers not only can be restricted in certain ways within the confines of the Second Amendment, but that silencers are actually entirely outside of the boundaries of the Second Amendment, are not protected at all by the Second Amendment. And this is something of a growing concern to the point where this case has taken on new meaning, I think, for me and for Silencer Shop. And we're going to fight this case fairly aggressively as a result. So we are in it all the way, whatever it takes.
Well, thank you for that. And it truly is a pleasure to get to work with y'all. Yes, Silencer Shop is a major backer of this case financially, but honestly, I think just as important as that financial backing is having, your help thinking through the issues in this case so that we can really think deeply and get the best arguments put forward in conjunction with the plaintiffs and the attorneys who are actually litigating the case. So it's fun, it's exciting, and we're I'm sure on the same page as you that we're hopeful for a quick victory here, as quick as reasonably possible. So we're still optimistic on that front, but we've got a lot of work today, we've got a lot of work ahead of us to get there. But I'm fairly confident we're going to get there. And as an aside, I want to make a note that when Chris and I discuss this case, we're likely to refer to it as our case. That's just partially because we have such a deep love of silencers and are very hopeful that we will have a victory here and get to bring silencer rights to the citizens of the 8 states where they're currently banned. But when we say that it's our case, we don't want to take anything away from the brave folks who came forward to challenge this unconstitutional prohibition on suppressor ownership in Illinois. Really, ultimately, this is Carlin Anderson and Dave Clark's case, and we at ASA-F and at Silencer Shop are, like I said, honored to be in the trenches with them as we all seek to bring suppressor rights to folks in Illinois and thereafter to the rest of the country. So, as I mentioned at the outset, the purpose of this video is to give you some updates on what's happened in this case since we last came to you in May. And fortunately, there's a lot that has happened, and so we've got a lot to discuss. So when we last came to you in May, the case had been stayed by 90 days by Judge McGlynn. And here's the latest. So in June, Judge McGlynn ended up lifting that stay earlier than we thought he would. But he, in the same movement, consolidated our case with Morse v. Raoul, which is another case challenging the constitutionality of this Illinois suppressor ban. As part of that consolidation, the case was transferred from Judge McGlynn over to Judge Duggan, who's also in the Southern District of Illinois. So that's the first major update, is the case is now consolidated with Morse v. Raoul and is going to be heard by Judge Duggan, not Judge McGlynn, still in the Southern District of Illinois. And that consolidation doesn't mean that it's now one case. What it means is that these cases are going to proceed together on the same track, but our plaintiffs, so Carlin Anderson and Dave Clark, we're still represented by the folks at Cooper and Kirk, and the folks over at Morse v. Raoul are still represented by separate counsel over there, Stephen Stamboulier and a few other folks. So it just means that both sets of lawyers are going to be making arguments at the same time and in front of the same judge. So after that consolidation happened in June, we also heard the answer from the state of Illinois to the case. And the state of Illinois filed its answer and then filed a motion for judgment on the pleadings, where they argue that suppressors are not arms and therefore are not protected by the Second Amendment at all. So that's the next major update, is we now know what the state of Illinois and the defendants in the case are going to argue. After Illinois put forward that motion in July, we filed our response to the motion, where we argue that suppressors are clearly arms and that they're clearly protected by the Second Amendment. And then after that, on August 4th, Illinois filed its reply to our motion, further arguing that suppressors are not protected by the Second Amendment. So that's a lot of moving parts, and that's a lot of lawyer speak. But thankfully, we've got Chris here, and together the two of us are going to try to parse through some of that. Chris, would you mind explaining the argument that Illinois makes in its answer?
Yeah, sure. So the answer, there's two components that we've seen recently. There's the answer, and then immediately after they answered the Anderson complaint, they filed their motion, which is the motion we're going to talk about today. The answers in federal state court cases are typically very procedural, very technical, hyper-technical, and honestly, frankly, typically pretty boring. And this one's no different. It's a lot of repeating what we say in our pleading paragraph by paragraph and then saying we admit it or we deny it or we have no position on it, right? What was interesting about this answer, I thought, is that the plaintiffs make a few pretty benign, I think, unquestionable, undisputable statements about silencers. For example, they say that silencers don't actually completely silence a firearm. And instead of admitting the basic, simple statements like that, the state actually took the position, and they used a lot of legal mumbo jumbo saying, we lack knowledge and information to form an opinion as to the accuracy of the statement. And that's a lot of lawyer speak for, we don't know, and we're not willing to take the time to find out or figure it out. And I thought that was somewhat profound. You get that a lot in defensive pleading, so it's not unusual. But in this case in particular, where the defendants are the heads of the state police, the attorney general, the heads of the county police, these are the leaders of the law enforcement agency charged with enforcing these regulations, refusing to say whether they have any opinion on such a benign statement as silencers obviously don't make firearms completely silent. and instead saying, we don't know and we don't have an opinion on this point, that struck me as almost an admission that they don't really understand the items that they are regulating. So this answer was, and there were a few moments like that in their pleading. We don't have 2 hours to talk about their responsive pleadings, but there's a lot of points in there like that where you think, they could have just admitted that and moved on and we'd all be better off. But I think the real meat is in their motion for judgment on the pleadings, which we need to talk about.
Yeah, absolutely. I mean, you make some good points there, that these are the folks who should know, and they're claiming ignorance as to some basic facts. I do imagine that, if they took the time to ask around inside their law enforcement divisions, there were probably some folks who do know how silencers work in practice. But go figure. Yeah. So then let's jump right into the motion for judgment on the pleadings. Would you mind taking us through that, why it's important and what they're arguing there?
Sure. So this is something akin to a motion to dismiss. It's filed under Federal Rule of Civil Procedure 12C, and it's a motion for judgment on the pleadings. But the court has to look at the same questions and answer the same questions that the court would have to answer if it was a regular motion to dismiss, which means that the court has to look at the plaintiff's pleadings, not the defendant's responses, in deciding whether or not the plaintiffs have actually alleged a claim. So what they've essentially argued is fundamentally silencers are not protected by the Second Amendment. And that's why this litigation is so important. Right out of the gate, the first thing we've seen after we've moved past the basic procedural points of answer or plead and answer, we've immediately gotten to this question of, are silencers protected at all? Do they have any protection under the Second Amendment? So this is an important point in the litigation. It'll likely drive a lot of the rest of the lawsuit. And their primary argument is silencers are not arms. They're not bearable arms, therefore they're not protected by the Second Amendment. And they raise 2 points to support that. Number one, they say silencers are not weapons on their own. A silencer sitting on a table without a firearm can't fire a bullet. So it's not a weapon. Therefore, it's not an arm. Number two, they say silencers are not really necessary for the effective use of a firearm. A firearm can still fire without a silencer attached to it. So those are the 2 arguments that they're making. Under the first point, where they're saying that silencers are not weapons and therefore they're not arms, they look to the Heller definitions, which is a good place to start. But I point out that their pleading really does a good job of I say a good job. They clearly are indicating they don't want to talk about Bruin. They want to ignore Bruin as if it never happened. So they say quickly, Bruin doesn't actually deal with the question of what was or was not an arm. Therefore, we're not going to talk about it. Let's talk about Heller. So they're ignoring all of the great language in Bruin that further puts some meat on the bone that was left by Heller, right? But so they start with Heller and they say, look at the definitions, right? The weapons of offense or armor of defense. That's the first dictionary definition cited by Justice Scalia and Heller. And then the second definition is anything that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another. And they frame most of their argument under the first point with regard to those definitions. What they're failing to do is look at the rest of the Heller discussion after those definitions were used. The very next paragraphs in Heller actually cite to additional definitions. They cite to one definition where one of the, I believe it was a dictionary, distinguished between arms versus weapons and said arms as opposed to weapons, indicating that weapons is a subcategory of arms. It's not the exclusive category of arms. And they also glaze over or fail to acknowledge another definition that talks about all instruments that constitute bearable arms. And that word instruments, you see that used over and over again in Heller and Bruin as an alternative to saying, for example, all weapons or all firearms. No, it's all instruments that constitute bearable arms. So this is a broader category. And then backing up a second and looking at the 2 definitions in Heller that they actually do focus on, The weapons of offense or armor of defense is definition number one. And then definition number two being anything that a man wears for his defense or takes into his hands or uses in wrath to cast out or strike another. The second definition, we've already talked about weapons and we've already talked about armor. So the second definition was included by Justice Scalia in the Heller opinion to talk about other things. It says anything that a man wears or takes into his hands. So it's not limited just to weapons. It's not limited just to armor. So there are a couple of fundamental flaws in their definitional analysis. So that's the overview of what they're arguing.
Which is an incredible summary, and you make very important points there, which are that as an initial point, they're basically trying to ignore Bruin because that's not great for them. So they go back to Heller and then essentially try to cherry pick definitions and try to find the most helpful definitions for them, try to fit awkwardly suppressors into one of those definitions and then cast aside or just ignore the definitions that help our side of the case, where we believe very vehemently that suppressors are in fact arms, that they constitute arms, that they're therefore covered by the Second Amendment's plain text, and that Illinois has to get to the second hard part of the Bruin test. And I should back up there, and explain. We've discussed this previously in some of our chats on this issue, but the Bruin standard is such a powerful standard. The standard the case laid, the Bruin decision laid out, which is, essentially two parts. That if a particular conduct is covered, if the Second Amendment's plain text covers an individual's conduct, then the state or the body that is trying to regulate a particular conduct has the burden of showing that there's a historical analog that in the 1791 or 1867 period that would justify their conduct infringing on that. That would justify their regulation and potentially infringing on that conduct. Let's jump right in from there into the Anderson response to that motion, because that's the meat of it. That's, as you've laid out, the other side is trying to argue suppressors, silencers are not in fact arms, and therefore they're not covered by the Second Amendment at all, so that they don't have to get to that harder second part of having to justify their imposition on the Illinoisans' right to keep and bear suppressors. So what's the response? What's the basic argument that the Anderson plaintiffs lay out, and then we can jump into why we think that's a better argument.
Sure. So, I mean, fundamentally, the argument that the state has set up here in this motion is something of a straw man argument. They're asking the wrong question. They're setting up the question of, is a silencer a weapon? And then they answer that question, it's not, because it can't on its own fire a bullet. And then they say, we're done, right? That's not the right question. So the question is whether the item is used to facilitate armed offensive or defensive conduct. And another way of looking at it, and this is the way that the Anderson plaintiffs have responded, is that the question is the conduct of possessing a firearm equipped with a silencer protected by the Second Amendment? Is that firearm equipped with a silencer an arm under the Second Amendment that deserves the constitutional protection? And the answer to that is yes. And the goal of, I think, making that argument is to highlight the absurdity of the state's position that things that are clearly intended, designed, used, commonly used for armed offense or armed defensive conduct would not be considered by the framers and at the time of the ratification as being covered by the Second Amendment. There's really two absurdities to it. One is the idea that at the time of ratification of the Second Amendment, having just fought a battle against one of the world's greatest militaries and relying on citizen soldiers without a true standing army, and relying on citizens to go into their homes and take what they have, what they already possess as individual citizens, and bring that to the battlefield, that they would be parsing out and saying, well, those things, yeah, they're super useful when you're using your firearm, but they're not covered, they're not protected. That's absurd. The second absurdity comes from the idea that if you go down the path that the state of Illinois would have the court go down, which is that silencers are just accessories, or they're just component parts, and therefore they are not a weapon, and therefore they're not protected. That same logic could apply to any component part of a firearm. And you start talking about, well, what single part of a firearm is capable of firing a bullet on its own? And the answer is none. It operates as a system. So,
Right.
there are a couple of absurdities with the state's response. The other point that they try to make after they go down the argument of saying a silencer is not a weapon, therefore it's not an arm, therefore it's not protected, they recognize that there are clearly things that are not weapons that are protected, such as firing ranges, such as some type of ammunition feeding device, although they're going to contest whether you can have 9 rounds or 11 rounds, right? But they recognize there are going to be some things that courts are leaning towards protecting under the Second Amendment. And so that's why they have their second argument, which is that firearms are not truly necessary for the effective use of the firearm. And that is the type of analysis that Scalia and Thomas and the Supreme Courts in Heller and Bruin clearly do not want courts to be engaging in. This kind of analysis of how good is good enough? How effective is effective enough? Does the firearm function without a silencer? Sure. Does that mean a silencer is not protected by the Second Amendment? No. The same type of analysis, again, you reach these absurdities where if you apply that same logic to firearms themselves, you could say, well, once you have one firearm, you don't need a second firearm. So all the other firearms are not protected because they're not necessary to the effective use of the first firearm. These are all, of course, absurdities. So, yeah.
I mean, they absolutely are, and that's really what it gets down to, and that's where I think the Anderson plaintiffs, in the response, did a great job of countering those by saying, look, I mean, suppressors, like you said, aren't necessary to the function of a firearm, but nowhere in any of these tests is necessity a requirement. There's no necessity threshold in any of these tests, nor should there be, and the Supreme Court has made that very clear time and again, and it's very interesting that Illinois is trying to make that argument, and that sort of dovetails interestingly into another case that's active in Illinois that might foreshadow what next steps are in this case, and that's the Napersville, the consolidated assault weapons ban cases that are currently before the Seventh Circuit Court of Appeals. Should we chat about that a little bit, because I think that gets into what's likely to happen next. I should say before that, we're still waiting on a ruling. We don't know exactly when we'll expect that from the judge. And that ruling will, as you mentioned, Chris, be a very important one because we are at this threshold question of, Illinois arguing that suppressors aren't arms, therefore they're not covered by the Second Amendment. We're hopeful that we have the better argument. But what have we seen in this Napersville and the consolidated assault weapons ban cases that might shed some light? What's your take there?
Sure. So I've been following this case fundamentally because the judge, the district court judge in that case, was the same district court judge that presided over our case initially, Judge McClellan, and he entered a preliminary injunction ruling in favor of the plaintiffs relating to assault weapons, so-called assault weapons, standard capacity magazines, as well as a number of other items, including flash suppressors that are very closely related to the items at issue in our case. And Judge McClellan found that flash suppressors and other what you could characterize as accessories are protected by the Second Amendment because they do facilitate the same purposes that the gun facilitates, which is to hit a target at distance, right, with some degree of accuracy. And Judge McClellan even noted that flash suppressors I think it was undisputed, can aid in the accuracy of the weapon. It reduces recoil, similar to silencers. That's one of the points we're excited to make in this case, is that silencers reduce recoil. They reduce muzzle rise. They improve the accuracy not only for follow-up shots because of the reduced recoil, but for the initial shot as well because of muscle flinch reduction.
Right.
More
Some might
importantly,
argue they're way more useful than flash hiders and flash suppressors on a number of different vectors. I might argue that, in fact.
hugely, particularly in home defense. So we've all talked about the situation where you're inside your home, it's at night, everything's dark, your eyes are adjusted to the dark. You find yourself needing to use your weapon defensively. Without a silencer, that first shot may be the only shot you can take accurately for 5 minutes. So if you want to be able to safely handle that weapon and take accurate shots after that first shot, and frankly, even taking that first shot, you need to have something that protects your hearing, protects your sight, protects your night vision, allows you to hear your loved ones in the next room, allows you to see who you're shooting at clearly when you have family members in the house with you, and you need to be able to very clearly identify that target before you take any shot. Absolutely, they are functional when it comes to self-defense. But in the Barnett case, Judge McGlynn talked about some of those factors and noted that they were generally not in dispute, and used that as a basis to find that those accessories were also protected by the Second Amendment because they serve the same fundamental purpose as the firearm when engaging in armed offensive or defensive confrontation. So that case is obviously that was a great ruling. It's important for our position. That's before the Seventh Circuit, and it's been consolidated, as you mentioned, with the Naperville case. So we've been watching that case. They had oral argument in June, and I guess another in terms of forecasting what we might expect to see play out in our case. Timing is also an important point here. We had oral argument in June. It's now almost September. So these things take time. Federal cases can move fairly slowly. So there's a time expectation there. But also, having listened to the oral argument, I think there is some chance that the plaintiffs may not be successful in that case. The panel of judges that was drawn was not favorable to a Second Amendment position. The questions that were being asked by the panel of the attorneys, frankly, indicated that they don't agree with the Heller rationale and the Heller standard. So it'll be interesting to see how that plays out. If that, I think whatever happens at the Seventh Circuit, that case will be appealed to the Supreme Court. We'll see if it is taken up there. That's a similar path to, I think, how we would see our case play out, although hopefully our case plays out with a win at each level, right? But yeah.
Exactly. And, whether we win or lose at each level, we can also expect that it's going to get pulled up to the Court of Appeals. It's unlikely that if we won at the trial court level that Illinois would be satisfied with that result, right? But if we did get to the Seventh Circuit Court of Appeals, would we necessarily be in front of the same panel that we heard at oral argument here in the Naperville case? Or how would we expect that to work?
No, presumably it could be any subset. And frankly, we might see an en banc ruling as well in the Naperville case. So in that sense, it would be the same en banc if ours were to go that route.
Right. So a lot of variables here. We wouldn't necessarily have the same 3-judge panel at the Seventh Circuit Court of Appeals. In fact, we likely wouldn't have the same 3-judge panel. Although who knows? Stranger things have happened. But you're exactly right. It was very interesting to listen to that oral argument and listen to some very, from a Second Amendment perspective, it was tough to listen to some of the questions asked because some of the questions didn't evince a great respect for the Supreme Court's decisions in Heller or Bruin. And the attorneys made valiant efforts to get out of some of those lines of questioning where the court, it seemed, was questioning the validity of the holding in Bruin itself, which obviously the lawyers didn't come up with in this case. It's a whole different case than Bruin. Yeah. But you're right. It's going to be interesting to see what we come up with as this case proceeds forward. So, Chris, what else have we seen in this Naperville case and in that oral argument back in June that might be relevant here as we try to read the tea leaves and see how our case might proceed?
Sure. So one of the things stood out to me, and I want to say as a caveat that I'm not in the prediction business here, and there were a lot of things about the oral argument that didn't make a lot of sense. So I could be way off base in terms of what actually ends up in the opinion. It's sort of anyone's guess listening to that oral argument questioning. But I'll say it this way, there were some questions repeatedly posed by the judges on the panel that indicated that they were actually considering finding modern sporting rifles, AR platform rifles, and standard capacity magazines. But I want to focus on the modern sporting rifle component of it as falling outside of the protection of the Second Amendment, not because they are dangerous and unusual as a part of the second step in the Bruin analysis, but rather that they aren't arms under the Second Amendment as part of the gatekeeping step under Bruin, which is just, again, that's why I say I don't want to predict what they're going to say in the opinion,
Sure.
because that didn't make a lot of sense to me. But that was not just a fleeting moment. It was repeated questions challenging, number one, the commonality test stated in Heller as being a good test and a relevant test at all, which of course it is, a current Supreme Court precedent. And then secondarily, trying to pull the dangerous and unusual test from the second step of the Bruin analysis into the gatekeeper function and saying it has to be both common and not dangerous in order to be an arm. And the result of that might be an opinion potentially that says AR platform rifles are not arms under the Second Amendment, subject to Second Amendment protection, without even getting into historical analogs and historical analysis of statutes. So again, I'm not saying that's what's going to be in the opinion. Just listening to the questioning was surprising that they would even go down that path.
Sure, and that would absolutely be a wild development in the case law, and probably an outlier nationally. That would be very hard to square, to my mind, with what the Supreme Court has laid out in Bruin and Heller and McDonald. To imagine that AR-15s are not bearable arms is just hard to fathom under any definition anywhere, whether laid out by the Supreme Court or not, or just a dictionary definition, right? If we're defining arms, what else would an AR-15 be but an arm?
Right. Well, and that actually brings in one more point. We've seen this interesting flip-flop from the time of Heller to the modern discussions that are having in courtrooms today. Heller was focused on essentially an assumption that military style weapons were protected. And the question in Heller was, are non-military style weapons also protected? And of course, Heller said, yes, they are.
Right.
But the assumption that the court started with is military style weapons are protected. We're now in a position where there's a lot of focus on saying that the core purpose of the Second Amendment is home self-defense. Therefore, are military style weapons needed for that? And are they protected by this? So it's a flip-flop in the position from where we were at the time of Heller.
Which is fascinating that the other side just wants to have it both in either way, as long as they get to regulate and ban guns more readily, right? It's just the only consistency is that they want fewer guns. It's not why it should be constitutional one way or the other for them to do this. It really is striking. Hopefully that doesn't happen in the Seventh Circuit case, but you're right. Those oral arguments were very enlightening. And some of those questions, just from a Second Amendment perspective, struck me as tough to square with where the Supreme Court has come down on this issue repeatedly. And
we should mention for anybody who happens to be watching this, that those oral arguments are available via YouTube. So if you go to the Seventh Circuit website, there's a link that'll take you to a YouTube page with all of the audio recordings. So those are available if you care to listen.
Well worth a listen to, and I thank you for pointing that out to me. I listened to it at your suggestion, and I wish I'd done it sooner because it was enlightening. There are really some very interesting and mind-boggling questions raised there. Hopefully, we can keep our fingers crossed and hope for the sake of the Second Amendment that the Supreme Court not the Supreme Court, but the Seventh Circuit comes down and finds that in fact AR-15s are bearable arms and are protected by the Second Amendment. But we're prepared here with this case either way. It's gonna how that decision is made. I mean, Chris, whether the case comes down one way or the other, it won't stop us from moving forward with this case, right?
No, we're proceeding. We're in it for the long haul. I think we had hoped that we might, particularly after seeing McGlynn's excellent, well-reasoned, thorough opinion, that we might see some support from the Barnett case, and we might still certainly, there's another step beyond the Seventh Circuit, but
Sure.
it'll be a while before we get to that step. So we're going to be fighting this battle at the district court level, and then at the Seventh Circuit, probably before we have support from the Supreme Court in the Barnett case. So that just makes this case ever more important.
It really does, and fun. It has been a lot of fun, and we're hopeful. As we mentioned earlier in the video, we don't know what the timing is going to be like. It could be tomorrow that we could get a ruling. It could be, I mean, who knows, months from now. What we know is that we will get a ruling, and once we get that ruling, that'll determine how we proceed forward. But what we know is that we're going to keep proceeding forward, and this case is going to go on until hopefully we've got a victory.
That's right. That's right. And there have been very few times in American history where it's been as fun and as interesting and as stimulating to be a constitutional Second Amendment lawyer. So these are interesting times.
They are interesting times and exciting times, and yeah, a lot of cases moving, a lot of moving parts. But like I said, we're laser focused on this one, and we're excited to hopefully find victory. Chris, is there anything else we should discuss before we sign off here?
I think we've about covered it. Obviously, any questions, I'm happy to answer and jump on another of these anytime.
Well, awesome. And thank you again. Thank you so much for joining us. Thank you for your time today. Thank you for your time and expertise throughout this case up to date. And thank you again to Silencer Shop and your whole team for the financial support, for the moral support, and for the intellectual support as we proceed forward with this case.
Absolutely. It's been great. It's been great working with you and great working with ASA and Knox. So thank you. And let's keep fighting the good fight.
Thank you. And until next time, this is Michael Williams signing off with Chris Boeck. Thank you again, Chris.